In 1985, I was nominated by President Reagan and eventually confirmed by the United States Senate to serve as Assistant Attorney General of the United States. For more than 4 years, I was privileged to serve in this position, heading what was known as the Office of Legal Policy at the Justice Department. Perhaps the most important of my responsibilities in that office was to offer recommendations to the President on federal judicial appointments. And every Thursday afternoon for 4 years, I would meet at the White House to discuss these recommendations. Usually the person sitting across the seat from me, representing the White House, was a fellow named Mitch Daniels, who offered very thoughtful guidance on these issues. I don't know what's ever happened to Mitch, but he made a great contribution to the process as well. During my time in the Reagan administration, the President nominated nearly 250 judges across the nation. In the course of preparing my recommendations to the White House, I interviewed many hundreds of persons interested in judgeships. And in the course of these interviews, my office sought always to abide by the standards that were clearly set forth by President Reagan himself. These standards were perhaps expressed best at the swearing in of Justice Antonin Scalia, at which the President stated the following: Hamilton, Jefferson, and all the founding fathers recognized that the Constitution is the supreme and ultimate expression of the will of the American people. They saw that no one in office could remain above it if freedom were to survive through the ages. They understood that, in the words of Madison, if the sense in which the Constitution was accepted and ratified by the nation in 1789 is not the guide for expounding it today, there can be no security for a faithful exercise of its powers. The Founding Fathers were clear on this issue. For them, the question involved in judicial restraint was not, and it is not, will we have liberal or conservative courts? They knew that the courts, like the Constitution itself, must not be liberal or conservative. Rather, the question was, and is, will we have government by the people? This was eloquent leadership, typical of President Reagan, setting forth clearly and unmistakably what he sought in his judicial appointees, as well as what he expected of those of us who assisted in those judicial appointees. And I shared his values, and I took them to heart in carrying out my responsibilities. As much as any president, President Reagan recognized his solemn constitutional obligation to preserve, protect, and defend the Constitution of the United States. In that regard, he appreciated that one of his most important responsibilities as chief executive was the exercise of his authority to determine and to transform the character of the judicial branch of our national government. To ensure that the Constitution was preserved, protected, and defended, President Reagan repeatedly made clear his determination to appoint to the bench only those who were committed to the rule of law and to the enforcement of the Constitution. The Constitution in the sense in which it was adopted in 1789 by we the people and their elected representatives. President Reagan understood that he would have been derelict of his constitutional duties if he were to appoint judges who were willing to create new constitutional rights out of thin air, usurp legislative and executive branch functions, or otherwise fail to bind themselves by what Jefferson described as the chains of the Constitution. The role of the judge, as he saw it, was to seek out those constitutional meanings consented to by we the people, and to say what the law is rather than what it ought to be. This classical conception of the judicial role was guided by a standard of fidelity to the Constitution as written. At the core of this vision was the belief that the judicial power of the United States stemmed from the consent of the people and could be exercised exclusively to promote the will of those people. We, the people, were sovereign, and the judge's role was to act as their agent in ensuring faithful adherence to our highest law. One vignette from the previous administration's judicial selection process that is the administration preceding Ronald Reagan, illustrates the sea change that took place in this area upon his election. I recall a confirmation hearing shortly before his election, when I served on the Senate Judiciary Committee, at which a member of the committee asked the nominee before the committee, "Sir, if a decision in a particular case is required by law or statute, and yet that offended your conscience, what might you do in that situation?" The nominee answered, "Senator, I have to be honest with you. If I was faced with a situation like that and it ran against my conscience, I would have to follow my conscience." The nominee went on to explain the standards with which he would replace the law of the land by his personal conscience. "Senator, I was born and steeped in this country," he said, "and I am familiar with its traditions, its beliefs, and its philosophies, and if I felt strongly in a situation like that, I feel it would be the product of my very being and upbringing. I would have to follow my conscience." This nominee was ultimately confirmed. To President Reagan's mind, however, for a federal judge to render decisions according to his or her personal conscience rather than the law itself was unconscionable. I am enormously proud to have worked for President Reagan for 4 years, and in my 12 years later on the Michigan Supreme Court, I've thought often of his thoughts as to what characterizes a responsible judge, the judge acting within, not above, his judicial powers and authority. And when I am no longer a justice of your Supreme Court, if I can look back upon my service on that court and conclude that I have lived up to Ronald Reagan's standards of what a judge ought to be, that I have abided by the values and principles that he insisted upon in his appointments, then I believe deep down I will have been faithful to my obligations to the law and to the people of our state. And day after day, in deciding my first 20,000 cases on the court, there's never been anything more important to me in each of these decisions than doing my best to try to adhere to the values insisted upon by Ronald Reagan for his judicial appointments. Thank you for the opportunity to share my thoughts.